Yeah. Yeah, we've got a lot of great information to share,
It's
and
pretty
I'm
specific
excited.
today,
Hmm.
um, and meaty, but I hope for those of you that are joining that this is going to be super useful. Let's see. Do they have the ability to type in the chat and tell us? Let's see. Let's see if the chat's working today. I think just Q&A maybe. No,
Hmm.
maybe everyone can chat perhaps. So if you guys can chat or ask questions, tell us where you're from, if you're in the middle of a case, or if you anticipate getting a case soon. Okay, let's see. I'm just pulling up the presentation.
Yeah, don't use the chat, just use the Q&A. So anybody that wants to tell us where you're logging in from or any questions you have, feel free to put that into the Q&A.
All right, now I'm going to share my screen and hopefully I have the presentation mode correct. Let's see. All right, how we doing?
Looks good.
Yay. All right, so where's everybody from? Did we get any answers?
Let's see here. We got North Carolina. Let's see. Trying to
We
move
got
down here.
Chandler, Washington State, Idaho, Indiana, Tucson, Ohio, Michigan, New York. We got people from all over. And it looks like they've got cases that are they're in the middle of cases or they have cases coming up. So good. This is going to be very good, useful information. Thank you all for joining today.
Yeah, you are. I'm seeing the slides. So we got a message here that someone's seeing a black screen, but I
Oh,
see slides. So hopefully you guys are seeing the slides too.
can you let us know if you can see the slides? Somebody raised their hand. I hope that means yes. We got another hand raised. I think we're okay. All right. So today's presentation is on combating negative custody evaluations. And we're going to cover preparing, engaging in these evaluations, and defending against bad custody evaluations because they can and do happen. So, first, what is the custody evaluation? When would you even want one of these?
Yeah, I'm going to let you take the lead on this, Billy.
Okay. So if you've got a case involving custody, so obviously children have to be involved. You cannot get psych evals, usually if you're or anything like an independent evaluation unless there are children involved. The only exception would be, let's say, if you were someone who was requesting spousal maintenance and you wanted to prove a disability, then you might have an evaluation. But for today's purposes, we're really talking entirely about cases with minor children where things are complicated. Nobody agrees on the facts. Mom says dad's abusive, dad says mom's abusive. The allegations are serious or dangerous. You need the child's perspective. Let's say mom says the kids hate dad, dad says the kids hate mom. Nobody knows where the kids stand. And basically, if you have a big mess that the family court judge is not able to figure out, or you think that it is such a complicated case, you really need a professional to dive deep, and the judge won't be able to understand what it is you're trying to communicate because of its complexity. That is when you might want a custody evaluation. But every time, whether or not to use one is not an easy decision. There are pros and cons, there are risks involved. And so that's why we start here. Should you even think about it? Sometimes they're ordered. Sometimes the judge orders them right off the bat. And sometimes you provide a motion to the court to ask the court to appoint a custody evaluator. Other times you hire your own independent evaluator to be your advocate. This is your expert witness. And as long as they're qualified as an expert witness, there's nothing that stops them from testifying as to their opinions and you using a report as an exhibit. We don't have that happen nearly as much as we have judges order evaluations. Let's talk about the risks. It's very easy for each and every evaluator to have their own bias and subjectivity. Depending on the type of evaluator, they may also have a lack of training, and you would be shocked as to how often people don't have up-to-date training. You might have somebody who's been doing this for 30 years, but they might be super misogynistic. I've seen that happen. They might have very inconsistent standards. The stakes here are high. They could have huge impacts on children. They could misinterpret data. There could be confidentiality issues or exchange of information issues. I've had issues where I was trying to get documents from the other side and the judge went ahead and said, nah, they'll just give them to the evaluator, which is a complete violation of due process. But sometimes when you have that third party involved, a judge will really lean on that third party and depend on them in ways they shouldn't. They're also usually paid for privately. They can delay your case and they can creep in scope, which can also increase your cost and your time to get your case done. Do you have anything to add on this?
Yeah, often the judge will order the parties to divide the cost, and that can be $1,000 a piece, a couple thousand, depending on the final cost. And when it goes this way, there aren't, two competing evaluators. It's going to be just one evaluation that both parties have paid for. And then, you may or may not be happy with the outcome, but yet you don't have a separate evaluation to attack the evaluation that you weren't happy with. So this can become a really expensive endeavor for something that you may or not be happy with the outcome.
Absolutely. So who are we? My name is Billie Tarascio. I'm an Arizona family law attorney. I've been licensed since 2005, practicing only family law. And this is my lovely and wonderful business partner, Julie LeBenz. Julie, you want to introduce yourself?
Hi, everybody. I am up in Yavapai County. I'm also in Arizona. I've been practicing family law since 2009. I've been an attorney since 2006. And Billie and I both share a passion for helping people navigate the really complicated family law system, even if you don't have tens of thousands of dollars to spend on a lawyer.
Right. So in family law, there's a huge access to justice gap. Everybody has family law issues. Everybody, not everybody, but we all know people who are incredibly impacted by family law. It comes up all the time. And it's not really optional if it comes up. If you get dragged into court for a custody case or a child support case or a divorce case, you have to do it. It's not optional. You can't opt out. And many people cannot afford a lawyer. So Win Without Law School is a company that Julia and I created together to support people who are representing themselves. It is the only company of its kind that really offers information, courses, and individual coaching, both through groups and individual coaching if you pay for it, to teach you how to represent yourself in court effectively. So today's webinar, and one of the things we do through Win Without Law School is these webinars. So today in this particular webinar, we're going to talk about the different types of evaluations, custody evaluations, preparing for your custody evaluation, determining what evidence you should provide to the evaluator, taking a position on ex parte contact, and the discoverability of expert materials. Now that is legal speak. So maybe you can non-legal speak that for me, Julie.
So ex parte means that only one of the two sides is having communication and contact. So that means there can be conversations and interviews and all sorts of gathering of information that happens without you being present or knowing exactly what's going on. And then there's this issue of, can you discover, meaning can you get a copy of the notes from the interviews or emails that were done between the expert and or the evaluator and the other party. So there's not only this issue of you not being involved in every step of the process, but a question of, can you get a hold of any materials that were created by the custody evaluator?
Right. Or conversations that they had. Like, let's say the evaluator was having private and maybe what you consider inappropriate conversations with the other party. They were telling the evaluator lies and you never knew that. And so you never defended against that. That happens a lot. The other thing we're going to go over is how to combat misinformation or unfavorable findings or recommendations, pretrial discovery and motions, cross-examination of experts, because that's what they are usually. They're treated as experts. The different types of evaluations and evaluators. We've got best interest attorneys, guardian ad litems, court-appointed advisors, investigators, limited, focused, or comprehensive assessments. All of these are different types of custody evaluations. And so we're going to go through each one of them because there are differences, and understanding the differences between them and their role will really help you if you have to challenge those recommendations. A best interest attorney is an attorney. They're a lawyer, just like mom's lawyer or dad's lawyer. They don't make a report and act as an expert witness. They don't testify. They represent the children. And they have the ability to question witnesses, just like any other attorney in an action. They will make statements if they're asked, and the judge can ask them for their positions. They can do pretrial statements. They can file their own motions. They're just another lawyer in the case. A guardian ad litem does not need to be an attorney. They investigate and interview all of the players involved. They provide reports, they testify, and they make recommendations. If a GAL is appointed, you're going to want to know, what are their qualifications? Where are they coming from? Are they a psychologist? Are they coming from a mental health perspective? Are they coming from a legal perspective? Are they coming from some other expert type of position? Court-appointed advisors. This is frequently used in Maricopa County. We don't really use GALs here in Maricopa County, but the court-appointed advisors act in that same role with that same scope right here that I just described for guardian ad litems. They don't have to be lawyers. They usually are not lawyers. They meet with the parents and the witnesses. Usually they also meet with whoever else lives in the home, including children. They have varying credentials and they testify as a witness, which means they're subject to cross-examination. And if you've got questions on any of these specifically, just go ahead and throw them in that Q&A, okay? And we'll get to specific questions at the end as well. Comprehensive or limited family assessments, these are conducted by experts. These are usually forensic psychologists, doctors, MDs, PhDs, child welfare experts, maybe an addiction expert. They should have the highest level of credentials, although you're still going to want to look at every single one of their individual credentials when you choose. Most of the time when you ask the court to appoint someone, the court's going to say, who do you want to appoint? And you're going to want to know in advance who you are asking the judges to appoint. This can be wide in scope or limited in scope. You could do a specific addiction evaluation. You could do a one party, right? Where they wouldn't interview all parties. They could be brought in for a very specific issue in a case. They could be brought in to evaluate one of the parents for sex addiction, which I understand is a controversial term, may not even exist, but I have seen it happen where judges did order this type of evaluation. So it can be limited, narrow. Sometimes a judge will order a mental health evaluation of one of the parties. That counts as this limited type of assessment. They always issue reports. They're always subject to testifying and cross-examination. They can be the longest and most expensive. A comprehensive family assessment, a CFA or a CFE are different names that you'll hear from them. Those involve psychological testing for both parents, interviews of anybody who lives in the home, interviews of the kids, interviews of collateral witnesses. And CAAs can interview collateral witnesses, but most of the time they don't. If you're doing a comprehensive family assessment, they do interview witnesses. This can take 3 to 9 months. There can be more than one report. It can cost up to $20,000 or even more. Sometimes these things make your case worse. Here's what's important to know. Third-party evaluators are not legally allowed to make decisions. A judge cannot say parenting time will be per so-and-so's advice or recommendations. That is not allowed in Arizona. Third parties are only allowed to make recommendations. The judge has to make findings that are legally compliant with Arizona law. So they can't outsource that obligation.
And what that means is that the recommendation does not mean that that's the final decision. So keep that in mind. If you get an adverse recommendation, this is the time to start gathering your evidence so that when it goes to trial, you can convince the judge to not follow the recommendation and do something different.
Gathering your evidence prior to meeting with your evaluator. You have to decide before you meet with whoever this custody evaluator is, what story are you going to tell them? What evidence are you going to bring them? And it can be very difficult to determine what evidence is going to be effective. That has to be part of your overall strategy of your case. And Julie, you talk a lot about developing your overall strategy. And can you discuss how the evidence you choose needs to relate to that strategy?
Right. So it's really important to be clear about what law applies in your case. And then you want to craft your story and your evidence around the law that's applicable. One thing that can be really dangerous is if you don't have any sort of plan and you just talk and talk and talk and talk and talk, because you're likely going to bring up stuff that the evaluator can take and twist into a negative evaluation. You want to be very clear on answering a question, providing the information, and moving on. You don't want to go on and on and on, because that's when you can get into some dangerous territory. So be really clear. If you're looking to convince the evaluator that you should have the majority of the parenting time, or that you should have a certain level of legal decision making, then you're going to want to answer the questions within that framework.
Right. So the same evidence that you would want to be using at trial to prove X, Y, or Z is the type of evidence that you want to give the evaluator. But the evaluator is going to have a lot longer with your case. So while you might not be able to tell the whole story of, the 10 email sequence in trial, you can walk through that with your evaluator. I recommend separating your evidence by issue, putting it in a binder, and maybe creating a cover letter that says, here's the evidence I've selected for you. Here is what I think it shows, and here's why I think it matters to what you are being called to decide. Every single court-appointed evaluator has a order of the court, which contains their scope of work and what they have been ordered to do. And it's incredibly important that you know this document inside and out. You should know what it is that the judge has told them they are to provide information on, and make sure whatever you are giving the evaluator is relevant to that scope. Because if the evaluators start going outside of their appointed scope, that might be one of the reasons that you can challenge whatever their report or recommendations might be. Many times you have the ability to meet with the evaluator at your house or at their office. And this is a very strategic decision, and one that honestly I have a hard time advising my clients on what's better. Do you have any thoughts on that?
Well, regardless of what you decide, if you pick to have them come to your house, you're going to want to make sure your house is in complete order and that there isn't junk in the front yard, that there aren't dishes in the sink. It sounds silly, but I've seen evaluators just rip a parent to shreds because things weren't the way the evaluator thought they should be at their particular home. So if your home is not, it could be criticized to a great degree, then meeting at the evaluator's office could be a much better option for you.
And I couldn't agree more. I tend to think that meeting at the evaluator's office is the safer choice because it limits the amount of things that you can be criticized for. When you invite someone in your home, you can be criticized for anything. They're going to make judgments about you and your space. And those judgments might be good or might be bad, but they certainly aren't about what the thing is that you're there to discuss, unless there are allegations that your home is unsafe. So the safer choice, in my opinion, is to just go to the office and stay focused, because these people are human and they're in a position, they've been appointed to judge you, and they're going to judge you.
Mm-hmm.
You do need to disclose the evidence that you're giving the evaluator the vast majority of the time, but look at the scope of the appointment and find out if that is required of you. If it is not, you still probably are obligated to disclose the information, but you might have some more leeway on timing. What happens if you've met with the evaluator and then you're waiting, which is very, very normal, and something happens? Somebody gets a DUI, you reach a settlement, somebody's caught using drugs, there's a major medical emergency, there's a health emergency, somebody gets arrested. Those are updates that you are going to want to give your evaluator. Usually, you're not going to want to give your evaluator a play-by-play of the day-by-day interactions and conflicts that you're having with your ex. But if something major happens, then you're going to want to update your evaluator. Okay, you wait. You get the report back. You're reading the report. There's things in there that maybe you like. There's things that you don't like. You get down to the recommendations. Maybe some of the recommendations you like, maybe some of them you hate. How do you decide what to do with the report?
Well, I would start really going through it paragraph by paragraph and identifying what in each part of it is either factually incorrect. Do you have counter evidence that you could present about? And how did all of those pieces tie in to the final recommendation? And those are things that you'll want to start gathering and preparing for the final trial. And this will be in terms of presenting exhibits, your testimony, as well as cross-examination questions for the evaluator.
Yeah. So you are going to want to read this report in its entirety, just like Julie said, paragraph by paragraph, and write down throughout it what's wrong, what's inaccurate, what do you disagree with, what do you think is really good for you? Like, really digest this report. And then ask yourself, if the judge were to believe and to agree with everything in this report, how might that impact the outcome for me? Let's say after you read it, there's some things you don't like, there's some things you disagree with, but the overall report is really going to help your case. Then you're going to want to tackle that differently than if it comes back and it's in left field. Like it's beyond the scope of what they were there to talk about. It's really bad for you. It's filled with lies about you that you weren't given the opportunity to counteract. That happens a lot. Then you have some options. You can reach out to the evaluator and dispute certain findings and ask them to make corrections, but you should come prepared with evidence and not be upset. Okay. You don't want to come aggressive to the evaluator, but you can say, hey, I got the report. I have some concerns. These statements about me are 100% false. And here's my proof why. I'm asking you to correct your report. That is a perfectly acceptable thing to do, and you should do it. This becomes part of the court record, and I don't want any of my clients to have a court record that is incorrect about them. Even if the case settles, that's always going to be there as part of your case. So as much as you possibly can, you want to get them to correct the report. If they won't correct the report, you can still file an objection so that you can put those objections as part of your court record. I think that's really important. If you have a case that's going to go on for many, many years, and maybe you get a different judge, you have to make sure that the court record tells the story accurately, or at least that you've defended yourself as part of the court record.
Not only that, but this can be really helpful when it's time to cross-examine the evaluator. Because if you provided them with a bunch of corrective information and they refuse to take any action, now you have some really powerful cross-examination questions you can ask that can go to show that they're biased against you, or that they didn't do the job that they were supposed to do, or that their ultimate conclusion is based on false facts, and as a result, it should be rejected by the court. So it is important to take these interim steps to set this up, because if you don't, and then you present it all at the time of the trial, you're not, the evaluator could say, oh, well, I didn't know that. Otherwise, I would have made these changes. And you won't necessarily have the same impact you would have had you asked early on before the trial.
Absolutely. Julie is 1,000% correct. You're also making exhibits. You're showing the court, look, I reached out to the evaluator. Here's the proof I provided them. Here's the date. The fact that they didn't respond or wouldn't update their report definitely shows that they may have been biased against you or overworked or whatever the reason might be. This is kind of the visual that I like to use when determining how hard to go at something. Because when you've gotten a negative report back or a report that's wrong, you could spend a lot of money challenging this. You could subject this person to a deposition. You could subpoena all of their records. You could get in a very combative relationship with the evaluator, which is usually not a great idea. It's not as bad of an idea as being combative with the judge, but it's not the best idea. So this is something that I like to think about with my clients. Is what's in the report wrong? Does it matter? If it is wrong and it matters, that is when we have to challenge it and get the record straight. If they got something wrong of the details that doesn't have an impact on you or on your case, it's not a big deal. So like if they get birthdays wrong, if they spell your name wrong, these are things that can really upset people. If they mix up two witnesses and they say that one witness said this, but it was actually the other witness that said this. One of the things we're going to ask is, okay, yes, it's wrong, but does it matter? Does it have an impact, or are the recommendations fine? In which case you don't have to spend your time and energy correcting those things. Now, if it's really, really bad, maybe you and your spouse were like this, everything was even, could go either way. And now you get this report back and it's really, really bad. You have to adjust your entire trial strategy. You may want to subpoena the file and all of the correspondence from the expert. And they don't always want to give you these documents. That's why I mentioned earlier, you want this in the scope at the beginning. You want to make it very clear. And I suggest that everything is discoverable. And if ex parte contact is allowed, that everyone knows it must be disclosed to the other side upon request. Okay. If you don't deal with that early on, many evaluators will simply refuse to comply with what are legal and reasonable discovery requests. You may have to get your own expert to challenge the findings of the report, depending on just how bad it is. Or you may choose witnesses that contradict what is in the report that matters and is wrong and is very bad for you. You may want to depose the expert. You're allowed to depose expert witnesses. And that would allow you to really ask questions like, did you talk to this person? Did you talk to this person? Did you talk to this person? How many witnesses did you talk to on mom's side? How many witnesses did you talk to on my side? What's your training in XYZ area? Whatever it is. You should consider getting witness coaching for yourself, because if the report came back very bad, it means something about you wasn't likable, or you weren't able to convey what you wanted to convey to the evaluator. And that is a clue that you may be at risk of the same problem with the judge. So you want to consider witness coaching, or how it is that you came across, and adjusting that strategy for trial. And then, of course, you get to cross-examine this person. And most often that is all that happens. So this whole presentation is about everything that you can possibly do. Most people don't do all these things, but everybody does get an opportunity to cross-examine a witness. You also will likely be given the opportunity to have a position on whether or not that expert can or should testify via phone, or they have to go in person. And that's a strategic decision that you're going to need to make. Should you settle? Depending on what is in that report, you may want to rethink whether or not it's a good idea to go to trial. And if it comes back bad, it's really time to take a step back and to get real creative and to be very careful, because you have more control over your case if you settle. And the risks just went up of going to trial. Knowing all of this, should you ask for a custody evaluator? What are your thoughts on that, Julie?
I lean more towards not asking for one. If things go in your favor, it can be really useful evidence, but you just don't know what the outcome's going to be. So I don't favor asking for one. It's usually something that the other side will request, or that the judge orders based on the judge's own request. But it's definitely not my regular practice to request a custody evaluation.
Yeah, I tend to agree with you. And so if this is something that my client's really interested in, I'll really think long and hard about it, and whether or not there's another way we can get the evidence that we need in order to make our case. If there's another way that we can possibly make our case, I'm usually going to avoid these custody evaluations. But sometimes there isn't. Sometimes we've presented all of our evidence and the judge is not getting it. They're not getting something that we think is really important. And my client is very convinced that if there were psych evals and if there were deep dive interviews, then the entire context would be known. I think sometimes these can be very helpful when there are alienation issues or resist refuse dynamics, where if you're a parent and you're not getting parenting time, your child is not spending time with you, and you really need help getting time with your child, that can be a good time to use all of the court's resources. And so if you can't get therapeutic intervention, then maybe you can get an evaluation that'll help move things forward if you're entirely and completely stuck. So there are 100% times that I use this. Most of the time it's not my idea and I have to deal with it. But there are times when you do want to ask for this type of thing. Nothing about family law is one-sized. Nothing. So in every single case, we are having to make an individual evaluation of your specific case, your specific judge, your specific case history to determine, do you want an evaluation, and what type of evaluation, and what should you request? And every single decision has consequences. And so every time that we are in a case, we are litigating, we are fluid. It's always fluid. We have one strategy, and that strategy must always be subject to change and adaptation depending on what happens throughout your case. How can we help you with these cases? We have combined almost 40 years experience and hundreds of these cases that we've had to adapt and adjust and mold to. And the thing about Win Without Law School is you are buying for a very small cost 40 years of experience. That is probably, I think, the greatest value of what we bring to the table. At Win Without Law School, yes, you get information, but information is not really the most valuable thing. You can go to Google or ChatGPT and get tips on cross-examination. That is not where the value really comes from. It comes from the 40 years, the many, many times of winning and losing, the getting knocked down, the learning, the tweaking. So when you join Win Without Law School, you're going to be able to walk through your case with us by your side. You're going to be able to get answers to your specific questions. You don't have to guess. You get to process out loud what's happening with you, and you have a community. So you've got a community of other people going through what you're going through, and you've got a coach who's ready to help you. We give you confidence, we give you community, we connect you with others. Do you want to go through the courses?
So if you join Win Without Law School, you'll get access to our members area. And within the members area, we have video tutorials as well as forms that you can utilize for various types of family law cases. And the members area takes you from start to finish for a case. So we're not just showing you how to initiate the case and then you have to figure out the rest. We're showing you not only how to create a case strategy and initiate your case, but how to do disclosure, how to prepare for trial, how to engage in settlement, and then of course, how to effectively represent yourself at trial. As some bonus materials, we also talk about orders of protection. We have some planners and organizers to help you with everything. And then we also have some really detailed videos about trial skills.
The trial skills videos are so important. You do not want to go into trial without learning trial skills, even if it's our crash course. And the other thing that I think is incredibly valuable is the trial organizer. That's another one of those things that family law attorneys create and tweak over their career that just gets more and more valuable. That in and of itself, that experience plus those tools, I think are just so valuable. Now, here are some real questions that our members have and our answers. So what if a judge yells at a litigant?
You know, you'll want to pay attention to what was going on that led up to the judge getting upset. And you'll want to show some deference. So, you know, I apologize, Your Honor. And then if, you know, depending on what's going on, you can potentially try to explain yourself, but be sure to be very clear to not repeat or go over the same thing that made the judge get upset. Now, look, the majority of judges do not yell and engage in that type of activity, but there are certain ones that do. And so really, you're just going to want to not take it personally and make sure that the judge knows that you hear the judge and that you apologize for anything that the judge thought that you did that was disrespectful.
Right. All you can do is take it as feedback. How can I incorporate this information and feedback and not get shut down, which is so hard because you're already very, very nervous going into family court presenting your case. This is another question that comes up a lot at Win Without Law School. How do I communicate with opposing counsel when I do not want to?
So, excuse me, I got a little frog in my throat. Keep in mind that Some trouble you can get into is if you ignore the communications from opposing counsel. That can result in you being ordered to pay the other side's legal fees, and it can also really slow down your case. So when that communication comes in, you're going to want to read it and respond. And we help our members in Win Without Law School to figure out exactly how to respond. Because number one, they may not understand exactly what the other attorney is asking, and they may not know what to say in response. And so we help with both of those aspects.
I think that that's so helpful because it can be so intimidating when you get a letter from opposing counsel on the letterhead asking you all of these things, accusing you of things, maybe has information in there that isn't true. And so being able to process that with a coach at Win Without Law School is just so helpful. Here's another question. We have joint legal decision making. Am I obligated to give my ex birth certificates, social security numbers, passports, and immunization records?
So in general, you are required to share information and documents related to your children. There may be terms in your parenting plan about that, so you can review the plan and see exactly what it says. There may be certain circumstances that have to first be met before you need to share the particular documentation or documents. And then also realize that if it's something that you can get directly from the provider, such as getting the immunization records directly from the doctor's office, that can be a much better option than having to go through your co-parent if they're giving you a lot of pushback.
Absolutely. You don't have to be your ex's secretary. And at the same time, you want to be reasonable. Certain things have to be shared. You're only going to get one passport. You're going to have to share the passports. Most other things, everybody should have their own. Everybody should have a copy of, or not even a copy. You can get multiple copies of the official birth certificates, and you should do that. Here's another question that comes up a lot. I have so much evidence. How do I know what evidence to choose?
This is really important. And if your matters proceeding to trial, I recommend that you start by drafting your closing argument. So, what is the story you're going to tell, and how are you going to tell it? And then start identifying what evidence proves the points that are within your closing argument. So, you'll need to know, number one, what is the law? What are the issues in your case, and what is the law related to those issues? And what evidence can you present to prove your case? But really, a lot of people get caught up in stuff that isn't necessarily relevant, but it's more something that makes them upset, or that's a fight between the parents. When really, if you're looking at custody issues, you really want to focus your evidence around your children. So this is a broad question to ask, in general. Certainly within Win Without Law School, we would provide a more focused answer based on your particular situation. But in general, you may have an hour for your trial. You may have 3 hours. If you're lucky, you may have a day. So given the limited amount of time you have, what are the most persuasive points that you can make that match up with what you need to prove under the law so that you can make a persuasive presentation?
Other questions we often get are how to organize my evidence. And one thing I want to make really clear, we usually do a lengthy disclaimer in the beginning, but for those of you who are new, we need to tell you. So while Julie and I are licensed Arizona attorneys, we are not acting as your attorney when you join Win Without Law School. We are not representing you. That means you're not our client. That means nothing that you say to us is privileged, although we do respect and have confidentiality rules. Those don't come from the lawyer rules, they come from the rules of the company, which means that we have confidentiality and we extend confidentiality to you. But you're not getting representation. So instead of us speaking for you and coming up with your strategy for you, we are guiding you to do this the very best way you possibly can on behalf of yourself. We are your coach. We are there to help you do the best you possibly can do. And so if you have questions about that, let us know. Here's another question that comes up a lot. My ex is a narcissist. What can I do?
I think one of the best things you can do is get really clear about your case and get really clear about what you're asking the court to do and why. Because so often when you're dealing with a narcissist, you get all wrapped up in defending against their case and getting all wrapped up in everything that they're doing. But if you're going to spend all of your time on their case, you're really not representing yourself to your best ability. So I think that it's important to figure out what you're going to do and how you're going to present your case, regardless of what the other side is doing.
And you help people specifically figure that out when they're in the muck, when they're buried, when they're headed into court. There are a couple cases that where our members have recently gotten just excellent results self-representing. Do you want to share one of those stories?
Yeah. So your degree of participation is up to you. And we have some people that just use the materials in the members area and through that are able to resolve their case or are able to go to trial and get an excellent outcome. So you don't have to have direct contact with me. You can just utilize the materials. And for some people, that's enough. And they're able to figure out how to navigate through the system and end up reaching agreement. And for some people, their cases have been pending for quite a while. They had a lawyer at some point, but ran out of money for the lawyer. And then they get the information they need and win without law school. And then they're able to get a favorable resolution. Other people are much more involved in the program and they'll come to the live Q&A sessions. They use the materials. They're active in the Facebook group. And through that type of participation, they end up going to trial and they are walking into the courtroom with confidence. They're presenting exhibits and getting them admitted into evidence. They're engaging in cross-examination and really asking powerful questions and proving their points. And in the end, the judge completely understands their case and they're ended up getting the results that they want. Meanwhile, they're saving tens of thousands of dollars because at the end of the day, you know your case the best. You know, this is your life. You've lived it. You know the ins and outs. Whereas if you have a lawyer, you've got to make sure that you educate them so that they know all of your facts. And I've had several people in the group who have complained that they had a lawyer at one time and they talked to the lawyer and the lawyer was getting their case mixed up with a different client. So sometimes lawyers are juggling so many different cases that they really aren't able to keep things straight. You're not going to have to deal with that problem if you're representing yourself because it's your one and only case and it's your life. So you know exactly the exact facts that you want to present. You just need help figuring out how to present them, how to talk about it, and how to do it within the context of the law and the rules of procedure. And that's exactly what we teach people how to do.
So here is our pricing. Here is our offering. We have an essentials package, which is either $100 or $200 a month, $199 a month, or $600 for a year. For that, you have access to our private Facebook group, access to all recorded Q&A, and full access to courses and templates, trial binders, everything, all of the materials are there. And today we have a great deal on that package for those of you who are good candidates for that. Our interactive is what most people join. That's $300 a month, $299, or $14.99 per year. In this package, you get everything in level 1, plus you have access to weekly live Q&A sessions. Those are Monday through Thursday. 4 days a week, you have the ability to come meet with Julie in a Zoom meeting like this and get your specific questions answered. Now, Julie, one question people have is how much time am I actually going to have to ask Julie questions?
Um, I move through everybody's questions during that time frame, and not everybody shows up every single day. So some days there's only a few people there, and you can have a more extended amount of time. And the other thing too is even if there are a bunch of people on, you learn from other people's questions as well. So not only are you getting your questions asked, which you can do through asking questions live, or you can type questions into the chat and I'll answer those. But you also get to hear other people's questions, which you benefit from as well.
I want people to understand what a great deal this is. This is our regular pricing, and today we're going to give you a coupon code. But $300 a month, $299 a month, is less than 1 hour of my hourly rate, and it's less than 1 hour of Julie's hourly rate. And
Yeah.
you have the ability to have access for thousands and thousands of dollars less than what it would cost you for a lawyer. You get access to our experience and expertise without paying a retainer. It's pretty incredible. And then
It really is.
Go ahead, please.
A lot of people spend 10,000, 20,000 or more on a lawyer, and that doesn't even necessarily resolve their whole case. And here you can spend, for a month, a little bit less than $300, or for a year, right around $1,500 for not only coaching, but community, all sorts of different materials. And it's so much less expensive. We do have a lot of members who still have a lawyer, but yet do the program because it helps them reduce their overall legal fees, because they can use our materials and our Q&A sessions to get questions asked that would cost them $300 or more per hour to get an answer on, whereas they can just pay that for 1 month and get multiple questions asked and learn a lot about the process along the way. Because when you have a lawyer, the lawyer likely isn't going to take time to explain the overall process to you. But yet you can gain that information through this program at a fraction of what you would pay a lawyer.
Right, because you wouldn't really want to sit and listen to your lawyer for 3 hours, billing you $400 an hour about and giving you all this background. Like, this is information you need, but it's hard to get. And our final premium offering includes one-on-one coaching with Julie. This is the highest premium, best package we can offer, and it does not come discounted. So that price, $399 a month or $24.99 a year, that's the price. But we do have some deals for you on those other packages. Now, somebody asked, if I'm out of state, if I'm in North Carolina, can you still help me? The answer is yes. We have members from all over the country who are getting help, who are walking into court, who leave court and say, like this just happened last week. Somebody went to trial after being a member of Win Without Law School. They went in, they came out, they typed in the Facebook group, I just had my final hearing. It was legal decision making, it was parenting time, it was a divorce, and I feel great. I don't have my outcome yet, but I know I presented my case well. And I cannot tell you just how happy that made me, because that is exactly what we can do for you. We cannot tell you you're going to win your case. But if you participate and if you learn and if you follow the advice and you join the community, you will be able to leave court and say, I did a great job, which makes me very happy. And here's another member of ours who doesn't live in Arizona, but he has had a great experience. He wrote in with this and he said he loved having the ability to pay a low monthly fee to speak directly with a licensed lawyer several times a week. He doesn't live in Arizona, but there's so much feedback. Experience was 5 stars. So thank you, Lance, for that feedback. Today, for those of you who are on this webinar, we are offering a 75% discount on level 1. That means you can buy that annual package for $599 plus 75% off. Use this coupon code WWLS75. That is only available on the level 1 annual package.
Right, that's the essentials.
And our level 2 package, we are offering a 30% discount. You can use the coupon code WWLS30. And again, we can't promise you're going to win your case, but we can promise you are going to be supported, educated. You're going to get a lot of experience and feedback from almost a lot of experience. Let's see, we have more questions here in the Q&A, so let's see about getting to them. We don't have a ton of time left, but let's get to a few of these.
Okay, first question is, what can you say to the CAA about not calling your witnesses you provided that could prove your case?
You would start with a question. Hey, I read the report and I noticed you didn't mention this person, this person, this person, this person. I provided those to you as collaterals. Did you have a hard time reaching you? Did they not get back to you? Why aren't they in the report? Start with that.
And then, of course, those people you'd want to disclose as witnesses for your case. And if you go to trial, you could call those people as witnesses to testify on your behalf, and then you can bring that evidence out that wasn't in the report.
Right. There's nothing that prevents you from bringing them as the witnesses except time, which is one of the reasons why we use these evaluators, is to get in stuff that you wouldn't have time to do. So it's okay to ask an evaluator to update their report.
Here's another question. What do you mean by scope creep? Can you explain that?
Yeah, so let's say your dispute is on legal decision making and you are fighting over a school choice issue. And all of a sudden the evaluator starts talking about, so-and-so's drinking, or whether or not, dad says mom has too many boyfriends. If that's not part of your case, that shouldn't be part of the evaluator's assessment. They should stay in their lane within the scope of what they were appointed to do. That's why on the front end, you want to spend a lot of time on the front end to make sure that the appointment of that evaluator says exactly what you need it to say. What's the scope? What are the rules? What are the parameters? And then hold everyone to them.
The CAA asked me to sign a release regarding my therapy sessions with my sons. Do I need to sign it if I feel it's confidential?
This is a great question. Not necessarily. You don't necessarily have to sign that. In Arizona, the mental health of all the parties involved is relevant, but we have case law on when the court can mandate you provide a HIPAA release, and it's not all encompassing. So the answer is not an easy yes or no, and that's one of those things that we would have to play out in the group and really talk about. We are almost out of time. I wanted to tell everyone again, you can sign up for Win Without Law School at winwithoutlawschool.com. And remember those coupon codes, WWLS75 on the Essentials package and WWLS30 on the Interactive, right? Interactive? Level 2.
Yes.
So thank you all for coming. I'm sorry that we couldn't get to all of your questions, but again, if you do join, you will be able to ask every single one of these questions in the lives. Thank you all for coming.